On the record in the matter of Dork Financial Credit versus Charlesetta Mason, file number 24-022635, council appearance.
May it please the court, Terry Weisshaus on behalf of the plaintiff, 86739.
And what's your name?
Oh, Charlotta Mason.
Okay, you're proceeding without an attorney? Okay, today's the date that was set for a pretrial. My understanding is that you all were instructed to complete a joint pretrial statement. Why was that an issue?
Your Honor, I was not aware of being asked to do one. I was, after we had already met, I was asked if we had done one, and I had no idea. I'm sorry, if your court requires one, I had no notice of that. I do think that we are, the defendant and I are on quite different pages as far as the issues, and I'm not sure how much middle ground there will be. I know that a plaintiff will be filing a motion for summary disposition.
Okay, who has a joint pretrial form? Did we email it to her? Did you receive an email from my staff counsel with the joint pretrial form?
I have not. I'm not sure if it went to a staff member and it didn't make its way to the file, but I did not.
I sent it. It's to White House Admiral Law PLLC.
What's your email?
It may have been to a different attorney. If it was to me, it would have been T. Weisshaus at Bro Law PLLC.
Yep, that's where we sent it.
Okay, I have not, but I can get it if I need to.
When did it go to her?
I sent it this afternoon.
It was sent this afternoon. I'm going to put you in a private meeting room with the defendant. You all can work through this worksheet. This worksheet needs to be filed with the court. This is how we kick out our scheduling order. And so I recognize that you all are not having a meeting of the minds and that you're on separate ends. That's why we're in court today. However, you need to discuss what the issues are, indicate that, indicate if you believe the pleadings are in order or if you are seeking a more definite statement or to strike any pleadings for whatever reason. Obviously, motions that you expect to file. If there's an omission of any facts, you'll indicate that. Exhibits, I typically just require them to be exchanged 1 week prior to the trial to the court. So that we know that there's going to be exhibits because she's not represented by counsel. Discovery will give you a standard time frame for any discovery that you believe is necessary. If you believe expert witnesses are required, you'll go through the entire worksheet and then we can go on the record if that becomes a problem. But that's a standard practice in this courtroom and we're not deviating from that because I don't see any reason why we would need to. That does not have any bearing on your ability to file any motions for summary disposition. We've not received any motions for summary disposition. Today's date set for pretrial, and this is how we hold our pretrials. Did you bring a device that you can get on Zoom with?
Yes, ma'am, I got it right here.
Okay, you need to get on Zoom. We'll get you in a private meeting room so that you can meet with counsel and answer these questions that are on the worksheet so that this joint worksheet can be presented to the court. And that way you'll know what your deadlines are as this litigation continues, okay? Thank you.
I'm gonna print off one for her so she didn't have to follow along. Oh, you got one.
Thank you.
Do I come back in with you?
You'll come back in when it's done, yes.
Okay, thank you.
Oh, that's amazing.
There's someone in the hallway waiting for Mike.
That is Mr. Ward. He's the plaintiff, and
Anybody for my court needs to come inside.
yeah, nobody else is out there. Mr. Ward?
On the record in the matter of Gateway Financial Solutions versus Evie Lynn Titus and file number 23-06239, council appearance. You're muted, sir.
Yes, good afternoon. Zachary Schisler, P number 82247, appearing on behalf of the plaintiff.
Okay, Mr. Schisler, today was the date and the time that was set for a motion for summary disposition. The court is in possession of that motion and has read the motion. Matter was scheduled today for 1:30. It's 1:53. No one's appeared virtually or otherwise on behalf of Evie Lynn Titus. Your motion indicates or seeks judgment to enter in the amount of $8,307.64 plus interest, costs, and fees. It indicates that the defendant, through her answer, has failed to raise any valid defenses and admits that she owes Gateway Financial. She's merely seeking a arrangement. Again, she's failed to appear and failed to file a timely response to your motion for summary disposition. Your motion is granted on its merits, and you can submit an order through my file.
Thank you.
Thank you. You're all set. the record in the matter of James Ward versus Melissa Brown, Chad Doyle, and Scott Leroy. File number 24-00533, council appearance. I can't hear you. Is he muted?
Thank you, Your Honor. I was just allowed this last moment to unmute. This is
Oh,
Timothy.
okay.
This is Timothy Perone appearing on behalf of the defendants Brown, Doyle, and Leroy.
Okay, what's your name, sir?
James Ward.
Okay, you're the plaintiff in this matter.
I'm the plaintiff, yeah.
You're representing yourself, correct?
Yes, Your Honor.
Okay, today was scheduled for a motion or two motions. One is just titled motion, the other one is a motion for leave to amend your complaint. There also was a motion for summary disposition. You received the motion for summary disposition, correct?
Yeah, I filed motions too, Your Honor.
I'm going to try to make my way through this because I'm not gonna miss anything. I have a motion, a notice of hearing for motion. It says a motion to amend complaint. And your motion in one sentence says there has been a crime committed 750.174. What kind of motion is that?
That's where, they had, I think that was the answer with the complaint.
You filed a motion to amend the complaint,
Right.
saying the motion only says there has been a crime committed. So when you make a motion, that means you're moving the court to do something. And I don't know what you are moving me to do in that
I'm
motion.
trying to get the video. See, that's the key thing.
Well, I wanna know, what are you doing with it, when you put this motion to amend the complaint and say that there's been a crime committed, what are you expecting the court to move to do on your behalf?
I would expect the court to allow me the video of the money that was taken from me at the time when I left the jail. And then the issue I have is where now I looked in here because they refused to give me any names or anything when we first
Okay,
started.
so let me stop you, because I'm gonna tell you right now,
I'm trying to see where
this was
you're
very,
at.
let me stop you because it's very confusing, because you're trying to navigate a system that I'm clear that you don't know how to navigate because you've not probably versed yourself with the court rules. This motion to amend the complaint, you filed a complaint against parties. That's how you started the lawsuit.
Yeah.
You made a motion to amend what you stated you were suing them for. What amended to add what? Or to take what out? What are you trying to amend the complaint to do?
Amend to because this was in small claims that they had went ahead and moved it to your court.
What is the
Where?
crime that was committed that you are claiming as the basis of your motion?
Where they had took in the money out of my account or took the money off.
Isn't that the basis of your lawsuit?
That's the basis of
Okay,
my
your motion
lawsuit.
is denied, it's improper. You can't file a motion to amend the complaint just to talk about the basis of your lawsuit. Don't tie up the court's time with that stuff.
Not the basis of my lawsuit.
Your motion, which is not properly filed, just says to amend the complaint. And the only thing you put in there is there was a crime committed. I asked you 3 times as to what you wanted to do with the complaint.
I'm trying to see where you're at, and I thought it was this one right here. It's a summons and complaint.
You need to know where you're at. You're the one who filed all these motions. And so this was filed on the 17th of May, but the motion is denied. Because you've not given me a basis upon which you feel your complaint needs to be amended. If the basis is because it's been moved from small claims to this court, that's not a motion to amend the complaint. Nonetheless, that's a motion for venue, not a motion to amend complaint. They changed venue.
They changed venue?
They moved it to.
They changed it, yeah.
Yeah, but you're asking to amend the complaint. So we're going to deny, I'm denying that motion. I gotta move to the next motion now. Okay, let's see here. You filed a motion to set aside the defendant's motion for summary disposition and motion for discovery.
Yes.
What is the legal basis to which you believe you can set aside a motion for summary disposition?
Basis is because, that is the main base of the complaint is because,
Do you know what a motion for summary disposition is?
sort of,
The court doesn't have the authority to set aside their motion for summary disposition. You have filed a complaint against parties. The parties, if they believe that the complaint or the allegations lack certain merits, can file a motion for summary disposition. You get to respond to that to show the court where, no, actually, to the contrary, this is an actual valid case, or I do have this information that would support the claim. Not,
correct.
you didn't do that. You filed a motion for the court to set aside their motion for summary. The court can't grant that. So that has to be denied. You, however, I'm also asking for a motion for discovery. Is that what you're asking for?
Yeah, because that's the whole issue why we're here in court, because they refuse to allow me to look at the video where they say there's only $5,000 when there's actually $8,000. You know what I mean?
I don't know what you mean.
Well, that would show exactly what was there, you know, how
You want
much money
discovery
was
so
there.
that you can try to prove your case.
Yes.
They filed a motion to get the case kicked, saying that there's essentially nothing really going on, or you're maybe suing the wrong parties. We're gonna address I can't set aside, I cannot set aside their motion for summary disposition. I'm gonna let them argue their motion. You've not responded to their motion. I don't see that you responded to the motion.
I have responded to the
You
motion.
filed a response to their motion?
Yes.
I have. I was waiting
Okay.
for the video so I can do a complete summary disposition, because it'll show the exact events.
Okay, let's see what this is. Maybe this is it. They should probably label stuff a little better, not just put response. Plaintiff answers? No. I'm assuming, is that supposed to be the response? What does your response look like? I have something here that's been filed. It just says plaintiff's answers. Was that supposed to be your response to the summary disposition?
That's it. Certificate of compliance, plaintiff's answers.
That's your response to their motion?
Defendant's motion for the summary disposition.
Okay, thank you. Mr. Perone, it's your motion. You can make your argument on the record.
Well, thank you, Your Honor. We're here today on the plaintiff's two motions. My motion for summary disposition is noticed for July 8th. But it is correct that the the plaintiff did file what he calls answers to our motion for summary disposition. And that would have been a valid reason for this court to deny his motion to set aside motion for summary disposition. Of course, there is no lawful authority for that. Otherwise, he has this other aspect of his pending motion for discovery, and we filed our response on that it is improper and premature. He's never made a discovery request, and nothing was refused.
Not true.
He hasn't identified what he wants or why he wants it. And there's generally no discovery in district court. And as we've mentioned in our motion for summary disposition, he named 3 people that have nothing to do with his money. Okay, and they weren't the ones who confiscated the money when he went into custody. They weren't the ones who counted it. They weren't the ones who were responsible for accounting for the money. They were completely unrelated to the incident of him being taken into custody and having his money put into storage. And that's the main basis for our motion for summary disposition. But we also established by multiple affidavits in our motion that the people who did handle the money counted it correctly, and that he signed a receipt indicating that the amount was correct. There was an extensive investigation conducted by Lieutenant Brown, who's listed as a defendant here. Her role was to conduct an investigation, and she concluded that the amount of money that was seized was accurate and fully accounted for. There was no missing money. He says he has more than what was on his person when he was taken into custody, but he didn't. And we've established that separately in our motion for summary disposition, but really he's naming 3 people who have nothing to do with it. And that's primarily the basis for our motion for summary, which is scheduled for July 8th. But he did answer, and he didn't produce any affidavits. He didn't produce any evidence. He just called it answer, and for the most part, he neither admitted nor denied. And so it ultimately comes down to he really isn't even putting up a defense to our motion. He just doesn't want it to be granted. That's all. Thank you.
Thank you. Sir, do you want to?
That's not a fact, what he's saying, the truth of the matter is, they've been holding the video from day one.
Did
I've been
you,
asking for the
you
video.
FOIA the
from day
video
one,
from them?
What?
How did you request the video?
Ocean Discovery. I talked to him. I talked to the other lawyer, Bonnie, and asked her to make a meeting. She
I
denied the
don't need, I
meeting.
don't need any, I don't need.
She denied the meeting. She didn't meet up with me or have a discussion, so I come up here and
You
filed
requested a
motion
meeting
to
with whom?
compel. Huh?
You requested
Bonnie.
him, who?
Bonnie Toski.
Okay. So
That's-
what does that have to do with you making a formal request for discovery or for information? So typically, if you want something from the government, whether it's a police report or anything else that is supposed to be accessible under the Freedom of Information Act, you make a FOIA request.
I did
Have you
that.
made a FOIA request?
I did all that.
When?
They denied me
When?
from day one, from the day it started.
When did you make the FOIA request?
The day that it started, that this happened, it was on the 25th.
25th of what?
I think it was the 28th or 29th. I made it.
Of what?
Um, 24.
Of what? We're in June. When did this happen? When did you
The
FOIA?
day that this happened,
I don't know when that, you're talking to me like I was there. You're supposed to tell me the date. If you don't know the date, you don't have a cause of action.
this has been going on for several months.
You're
now.
gonna tell
Nine-
me, you're the one suing, you better know your facts.
I do
what
know my
date?
facts.
Did the incident allegedly occur?
Back on the 25th,
Of what?
the first.
The first what?
January.
January 25th?
Yes,
Okay, of this year?
yes,
And when did you make a FOIA request?
the 28th,
Of January?
yes,
Your allegations for your complaint is that you were taken into custody in a criminal matter, is that correct?
yes.
And that you at the time had some cash on you?
I had 8,
I just answered my questions.
yes,
And you alleged that the amount that you had was $8,010.39 is what you're stating?
yes,
But that you only received back $5,910.37.
yes.
And but you're claiming damages of $7,000.
Well, yeah, because it's costing me more money than 7,000. That's because the initial was at small claims. So if 7,000 is the most that you can sue for.
I get that, but why are you claiming damages of $7,000? You don't get to just claim amount just because that's
Because of the
most.
damages that was done to me, what I had to go through to get it, the embarrassment.
The embarrassment?
Embarrassment and everything, yes.
What embarrassment?
Where I had to come to the court and have to deal with the court system because they stole money from me and they're supposed to be a law enforcement.
You can't allege that you lost
I didn't
2,000.
lose nothing.
You did,
The police, the jail.
you
had
cut
it.
me off again, you're gonna lose this case immediately, okay? You can't allege that you suffered a loss. If you're suing us, making a civil lawsuit, you need to know the terminology. You can't allege in a lawsuit that you suffered a loss of about $2,001, but you're suing for $7,000.
Because of the damages.
You have to tell me what the damages are. You have to allege that in your lawsuit. An embarrassment that you don't get, you
It
don't
is
get a,
alleged.
excuse
It
me?
is alleged,
Mr. Ward.
It is.
Mr.
Don't,
Ward.
please, I'm gonna correct him. You don't cut me off. You
I wasn't
understand that?
trying, I wasn't trying.
You have to show me some tangible damage. You're not getting any pain and suffering. You're not getting any money for embarrassment. Did you
Punitive-
how did it cost you $7,000 to try to get this money back that you
the
allege
time I
is missing?
spent- The time I have to spend at the library, the time I have to drive from Mason to here, it cost me in gas.
It cost you $5,000 in gas to
I'm
get
sure
here
it
from
cost me
Mason.
pretty close to that.
$5,000
In gas
From Ma- from
and
Mason.
time,
to go 10 miles away. It cost you $5,000 in gas.
and time,
Okay,
and time at the library.
okay, sounds good. I recognize that your motion was scheduled for a hearing on the 8th, but you're both here today. The court's already read the plaintiff's motion. And why are you suing these? I'm sorry, the defendant's motion. And you've already responded to the defendant's motion. Why are you naming these people? Why do you feel like they're the, if in fact you were lost some money, why were they the people that were responsible?
Because they're the ones that was involved in part of this, and they're hiding the evidence of the money being taken.
How were they involved? And how are they?
They're involved by, when they involved themselves, saying that they, viewed the videotape and all this extra that's not the factual basis.
Were
Because-
they present when you were arrested?
No, they're
Did they
the people I
collect? No,
contacted.
I didn't ask you to answer my questions. They weren't present when you were arrested? Did they take money out of your pockets, or did they confiscate the money when you were arrested?
I can't tell you exactly who took the money because they.
Did you see them take any money from you?
I didn't see anybody take the money,
Okay,
except for
so
the two who took it out of my pocket.
who were the two who took it out of your pocket?
Doyle,
You're saying Sergeant Doyle took money out of your pocket?
and no, Matthew Powell it is, sorry.
Matthew Powell took money out of your pocket when you
Yeah.
were arrested?
Yeah,
Not Chad Doyle,
no.
not
Chad-
Melissa Brown.
Melissa Brown and Chad Doyle is the ones that refused to show me the video where it shows that there was not 8,000. They're saying it's 5,000. That's not the truth. If they show the video,
Did
the
you sign
video
did you
shows
sign a receipt?
there was never no,
You never signed a receipt?
there was never no amount of money that was on that receipt, ma'am.
Mr. Perone, what, did you
I
attach,
asked for a receipt.
Mr.
I'm
Perone, did you attach a copy of this receipt? Is it,
Ye-
yeah,
Yes,
Or
I
exhibit.
did, Your Honor. It's on our summary disposition motion. It's one of the exhibits is the receipt. It's
which
just a little
exhibit is it?
slip of paper that has the amount and some initials on it, but that's essentially it. And the video, I had mentioned the video, but it really doesn't provide detail of showing the amount of money that was counted there. It just shows people's backs at a table counting money. It really
I have a
wouldn't
copy.
provide any level of detail.
Inmate name and number, James Ward. That's the receipt you're trying to show me, sir?
Yeah,
Okay,
inmate name and number.
okay. And you see the amount that was tendered on
It's
there?
got 3 amounts.
Do you see the amount on there?
It's got 3 amounts, yes.
I see $5,900.
4.
$5,910.36, and then their in quotation says 37 cents. Is that what you're talking about?
One says 36, one says 37. This one here says 5,594. This one says 5,528.
I don't know that that's an amount of money. I don't know what those numbers are.
Well, that's what it looks like to me. I'm not trying to be no rocket scientist, but that's what it looks like to me.
Okay, but James Virgil Ward, it has an inmate number on there and a receipt number, correct?
Yeah,
Okay, so then you were provided a receipt then, correct?
no. This was not provided to me. I asked for a receipt. when I was there. If you get the video, it shows right there too that I asked for a receipt.
Okay,
You can go look at this.
I'm not gonna go look at anything. I'm going to
I'm
make
just trying
my,
to prove
I'm gonna
my-
make my ruling. Just based on your statements today, the argument of the defense is that you named the wrong parties.
No,
Your state, excuse me?
no,
Your case is dismissed because you did name the wrong parties. You stated it here on the record.
that's fine.
These people were not even,
I'll-
hey, next is contempt. You named the wrong parties. The individuals you named were not even present during the incident alleged. You are trying to sue the people that you made a request for video from or a request for them to investigate because you didn't like their findings. But that's not a proper way to address that. You need to sue the proper or appropriate parties that you allege wrongfully confiscated your money if that's how you want to pursue. This case is dismissed. Mr.
will.
Perone, can you provide us a order, please, if you've not already done so?
Yes, I can, Your Honor. That would be an order granting defendant's motion for summary disposition.
That's correct.
Did you need other orders on the plaintiff's pretrial motions?
I need an order denying the motion for,
There was a motion to amend and then a motion to set aside motion for summary disposition and for discovery.
both of those motions also need orders for a denial.
Yes, Your Honor. We will get to that. We'll get those
And you
sent
can
in.
send those to my file. Thank you.
Thank
You're all
you,
set,
Your
sir.
Honor.
Can I
Thank
get your
you.
bonding number?
My who?
Your bonding number?
I don't have a bonding number.
Okay, well,
I'm a judge.
that's fine. You're
Yeah,
gonna-
your recourse is to file an appeal if you don't like my ruling.
No, I'm filing
That's-
1993.
Oh, you can do that as well if that's what you would like.
That's what I'm doing.
Have a good day.
You too.
And Your Honor, the July 8th hearing is canceled then?
That's correct.
Thank you, Your Honor. All set.
Thank you.
You.
Ms. Colston, I see you've returned.
Thank you. Did you leave this long?
You're muted. You're muted, Ms. Colston. Why is it not letting people unmute? Let's see here. I probably did something.
Okay, here we go. It wasn't letting me unmute myself.
Oh, okay. I don't know what
Yes,
happened.
Judge, I'm here at the correct time now for LVNV versus Christina Jeff.
Okay, sounds good. Thank you.
Thanks, Judge.
Who's on the Galaxy 9? What's your name, ma'am?
Gina Smith Kirkling.
Okay, Mr. Smith, I think she's here for your matter with LAFQ.
Yes, ma'am.
Let's see, I don't know why it won't let anybody unmute. Okay, there we
There we
go.
go. Yes, that's, we need to do a creditor exam.
Okay, I'll put you in a private meeting room. Let's see.
Thank you, Judge.
Ms. Smith Kirkling, raise your right hand. Do you solemnly swear or affirm that you will tell the truth and the whole truth under penalty of perjury?
I do.
Thank you. I'm gonna put you in a private meeting room with Mr. Smith so you can answer his questions truthfully and honestly, okay?
All right.
Thank you.
Thank you.
Let's see. Mr. Werber is here. Mr. Werber, which matter are you here for? Let me see if I can unmute you. This is not gonna let you for some reason.
Thank you, that worked. I am here on American Express versus Kevin Long.
Okay, sounds good. I don't have anybody here yet for Long or Duff. And let's see. It's 2:23. No one's in the hallway. Nobody's in the hallway?
No,
I'm
sorry.
Okay. On the record in the matter of American Express versus Kevin Long, file number 24-00630, council appearance. Why is it doing this?
There we go, Your Honor. Your Honor, is mine set for 2:30?
No, it's set for 2.
Oh, okay, great. Jeff Werber, P67124 on behalf of the plaintiff.
Today was the date and the time that was scheduled for objection under the 7-day rule. No one's appeared for Kevin Long. Let me see if I can pull this up in my file. Okay, the objection was filed to the entry of order filed by Mr. Long, indicating he mistook a date to be May 15th. And this was due to chemotherapy and having multiple appointments, plus he's still waiting on American Express to answer his fraud submission. And I think I do recall, did we reset this when he didn't appear one time and then we reset it again? Or maybe that was, I'm conflating this with another one.
I know he didn't appear at that May 13th pretrial. Let me see if there was one previous to that. That looks like the only one. A few points to make. Number one, they did complete the fraud investigation and came back and determined that my client is not taking this as a fraud matter. They don't see any evidence of fraud here. Number two, you can only object to the entry of the order to the accuracy or completeness of the order, and it was simply a default judgment being entered. So the order was accurate as to what happened. He failed to appear, and a default judgment was entered. So I asked the court to deny his motion.
Agreed. The motion is improper and will be denied.
Thank you, Your Honor.
Thank you. You're all set. Okay, now on the record in the matter of LVNV Funding LLC versus Christina Duff 24-01114, council appearance. Oh, I'm gonna have to try to unmute you. I don't know what's in.
Yes, Your Honor. Amy Colston, appearing in limited capacity just for today for the plaintiff. I am filling in for Mr. Brusen.
Okay, today was the date and the time that was scheduled for a motion for summary disposition. Matter was actually scheduled for 2 o'clock. It's 2:26. No one's appeared for Christina Duff. And so a motion is granted by default.
Thank you, Your Honor.
Mr. Brusen can provide an order if you have not provided one.
Yes, Your Honor. We will do that. Thank you.
Thank you. All set.
Thanks, Judge.
Okay, on the record. In the matter of joint financial versus Charlotta Mason. And counsel is present via Zoom, and I have to put it back here in the courtroom. Parties did complete a joint pretrial statement. I have here. This is a debt collection issue that the defendant is disputing. The plaintiff does not need to amend any pleadings. The defendant does not know what is needed, needs an attorney. Let's see. Do you intend to hire an attorney, ma'am?
No, I'm gonna try to reach out for like, legal service.
Okay. Let's see. Motions for summary disposition are expected. Defendant doesn't believe that is owed. The date is needed for your MSD. When do you expect to file your MSD, ma'am?
Probably 2 weeks from now. Within 2 weeks.
Okay. Assuming, based on how many times she's disputing the debt, that she'll need a MSJ date, but let's see here. MSJ. If we proceed that far, we need to go. Are you not seeking any discovery, counsel? Oh, you are.
We don't. It actually is the defendant that would like discovery.
Okay, August 5th, 2024 is gonna be the discovery cutoff. And so MSJ will be 9. October 7th. There's no omission of facts, exhibits, contract application, contract transaction history, and that information should be exchanged. If not during discovery, it should definitely be exchanged if we are going to proceed to a trial. There's no need for expert witnesses. Damages being sought $14,589.09 plus cost, interest, and fees pending time of settlement. There's no joinder of claims, low probability of settlement. A bench trial that we estimate will take no more than a couple of hours. Is that correct?
Yes, Your Honor, I believe so.
I'll note that here. Case evaluation, no. Mediation, no. Do you have any questions, ma'am?
Yeah, I'll be honest, I don't know nothing about this stuff.
You don't know nothing about what stuff.
Like what they're trying to say, like.
They're saying that you owe a debt.
Yeah.
It's a debt collection.
But my thing is, they're saying I owe for a debt, right? So
They're saying you owe a debt.
Yeah, so I asked them what was the debt was, but they can't prove what the debt is, but they keep saying consolidate.
Did you get a complaint in the mail? How did you know to come to court?
Oh, yeah, I got this, yes, I did, good, I got this right here.
So the complaint should tell you what you're being sued for. Did you read the complaint?
And I don't agree with it, she's saying a consolidation.
Do you have the complaint with you?
It's right here.
And you read the complaint?
Yeah, I read it. They're saying, what they keep claiming is a consolidation.
A debt consolidation? Okay. And so you're obviously disputing it, and so they would now have to prove that you did, in fact, have this debt, that you're the person responsible for it. And you would have to disprove by any evidence that you could gather through your discovery request, and you've sought discovery or requests in this. You want time to get information from them?
Yeah, because they say I owe you debt, okay? I know I probably do on with debt, but then is just saying, I got a car from them. They don't have it listed, and they send it, they say consolidation.
You get,
yeah.
Well, if you read the complaint and you don't believe that it sufficiently tells you what it is, then that's where we ask you if there's an issue with the pleadings. Maybe they need to give you a more definite statement. Maybe you don't understand. Maybe they haven't sufficiently pled. I don't know. But you've read it and you still don't understand what it's for, is what you're saying.
Yeah, no, because she's confusing me with my thing is that it's a card. That's what my thing is for the card. They keep saying consolidation. What's the consolidation for?
You said it's for a car, or are you saying car or card?
A car, man, just a car. I got a loan from them way back years ago.
So you're not disputing the debt?
No, I'm not disputing the car.
Excuse me?
I'm not disputing the car. I know I owe them for the car. I know that.
Well, that's what, so that if you owe them, then that would be the debt.
Yeah, but she's not saying the car. She's saying, she keeps saying consolidation. That means, like, I know it's confusing to me too.
No, keep talking.
Yeah, okay. And so my thing of it is, like, if they want to sue me for something I don't have, why do you want to sue me for a car I don't even have? I give it back to them, for one thing. She's not, they're not saying anything about the car. They're gonna sue me, Miss Simmons, it's like, if they're gonna sue me,
Let me stop you.
okay, go
I know
ahead.
you're not familiar.
Okay.
When you come into the courtroom,
Yes, ma'am.
I'm a judge.
Yes, ma'am.
We're not on the street. It's
Yes,
Judge
ma'am.
Simmons, okay?
I'm
number-
sorry, Miss
thank
Simmons.
you.
I
That's
apologize.
number one. If you can't remember, there's a sign right there that will remind you, okay?
Yes, ma'am.
The other thing is, you're not disputing this debt, is what you're saying.
Yes, ma'am.
They're saying that you had a loan agreement. The loan was for $12,128.39. Are you disputing that?
Yes, I am.
You're saying you did not have a loan.
Not for no 12 hours.
What, you're saying you had a loan for more or less than that?
They gave me, they said they gave me a loan for $15,000 for a car. I signed.
Well, the complaint says that the loan
They're
was
gonna
for
say
12,000.
payments.
120, you're disputing that amount. Is that a yes?
Yeah, because I'm just doing it, right.
Okay, okay. So it sounds like there is an admission that you did have a loan. It's a dispute about the amount. Is that correct?
Yes, ma'am.
Okay, sounds good. Okay, so with discovery, do you know what discovery is, ma'am?
Let me find something out that's not true or not.
Well, you're discovering facts, so that's a good one. That's a good definition. So you can seek to get information from the people that are suing you. You would have to follow the court rules as to how you seek that, whether it's going to be through interrogatories, which is a set of questions, or you can submit to them a request for them to provide documents. You would submit those in writing, okay? You need to do that before August 5th. When this goes to our clerk's office, they're going to get you some dates in the mail. And if your address changes, it's not our fault. It's your fault that you didn't tell us if you don't get this, because if you don't respond, she's already made it clear that they're gonna file a motion for summary disposition. A motion for summary disposition means they are asking the court to review what has been filed so far and to determine that the court can dispose of the case based on that in their favor, meaning you're responsible for the amount they're saying. When they file that, they gotta serve you a copy. When you get it in the mail, you don't get to just put it in this folder and not respond. You gotta respond, and you gotta respond in writing.
I did.
And well, that was your answer.
Yeah.
But you gotta now, when they file this next paperwork, you have to respond to that. If you don't, you still could get an automatic loss of this if you don't respond, okay? I recognize you said that you're gonna try to go seek some assistance from legal services. I don't know if they'll be able to take this case or not. If they do, that's great. Sometimes they can provide assistance, but they can't represent you because they don't have the capacity to represent everyone that may need help. But you should definitely go seek whatever assistance you need to seek from them. If they're going to file or represent you, they'll file an appearance with the court, letting us know that, okay? If we don't receive an appearance, that indicates to us that they're not going to represent you. You're still responsible for answering. Don't come to my court talking when I'm on the record. If you are going to be represented, they will let us know. Even if they don't represent you, you're still responsible for going through this process to defend yourself, okay? They're seeking damages, $14,589. That I'm assuming is an amount that includes what they said they loaned you plus what's accrued from interest since that time. I'm going to have you sign this because I don't think that you dispute any of the information put on that paperwork. And then I will sign it, and then we will give you a scheduling order sent to you in the mail with the new dates for your deadlines, okay? And they'll also have the dates for your trial, okay? Somebody had those files, let's see.
I'm adjusting. Thank you so much.
Thank you. Okay, do you have any questions for the court today?
I respect you for correcting me.
No problem. Do you don't have any questions about this?
No, I'm just waiting for you guys to send me something.
Thank you. Counsel, any additional matters for today?
No, Your Honor. Thank you.
Okay. Thank you. You're all set.
I can go.
You're
Thank you.
go.
Thank you.
Thank you.
Sit down. I ain't been in front of the judge, never. I'm just